Hello everyone and welcome to Uncivil Law. For today's case, we have a decision from the Court of Appeals for the Third Circuit. This is in the matter of an application for a subpoena against the ABC Corporation. The ABC Corporation is a corporation that has consumer data related to the internet. They received a subpoena for electronic records, and they were also ordered not to tell anyone about this subpoena for a year. They have asked for relief so they can tell people, and the Court of Appeals is analyzing whether this order is a prior restraint on speech, and if so, whether or not it's constitutional. So we're going to read this case and see what it has to say. Let's get started with this. The Stored Communication Act of 1986 is designed to protect legitimate law enforcement needs while minimizing intrusions on privacy systems of users, as well as the business needs of electronic communication system providers. The Stored Communication Act authorizes the government to compel an electronic service provider to produce a subscriber's information stored on remote servers, often referred to as the cloud. Kotaku says, I thought this sort of thing had been fought many times before with national security letters. Yes, it has been fought before with national security letters, and this is on par with that kind of thing. So this is, not the first time this kind of issue has come up, but it's being discussed here. Section 2703 of the Secured Communications Act allows the government to obtain search warrants, court orders, or subpoenas for subscriber data. These requests may be for non-content specific data, such as name, address, and product usage information, or content-specific data, including the contents of all communications, search histories, and save files. A. Service provider who turns over this information in response to a grand jury subpoena, as the case here, is a grand jury witness and is not subject to general secrecy obligations imposed by the rules of criminal procedure. So this is an important item to note. Grand jury proceedings are secret, and they are secret for the attorneys, but they are not secret as a general matter for the witnesses to a grand jury. So even though the attorneys can't talk about an ongoing grand jury thing, even though their clients may not be able to talk about an ongoing grand jury thing, witnesses as a general matter can talk about a grand jury proceeding. So if you're called before a grand jury to testify, you can say, I was called before a grand jury to testify, and say all about it. The federal rules do not apply to you in most circumstances. However, the Act authorizes the courts to prohibit a service provider from notifying anyone of its receipt of legal processes in appropriate circumstances. So this is somewhat similar to the national security letters thing, in which in they're being said, well, as a normal rule, you can talk about it, but we're going to prohibit it as a special operation of law. So we're going to look at the special operation and see if it is a just application in this circumstance. Section 2705 governs those occasions when the government may request that this court issue a non-disclosure obligation to service providers. That provision in relevant part states, a government entity acting under Section 2703, when it is not required to notify a subscriber or customer under Section 2703b1, or to the extent that it may delay such notice pursuant to subsection A of this section, may apply to a court for an order commanding a provider of electronic communication service or remote computing service to whom a warrant, subpoena, or court order is directed for such period as the court deems appropriate, not to notify any person of the existence of the warrant, subpoena, or court order. The Secured Communication Act thus permits the government to apply for a non-disclosure order when it seeks content or non-content data pursuant to 2703, unless the government itself is required to notify the subscriber of the request. With the general law being discussed as to when these orders can be applied for and when they can't be applied for, we now have to look to the circumstances of the particular situation to figure out if this restriction is just or not. The ABC Corporation, which by the way is a pseudonym, it's not really the ABC Corporation, it's just a name, so it could be anybody. The ABC Corporation, who could be Google or Cox or Comcast or anyone else for that matter, is an electronic service provider that stores its subscribers' content and non-content data on the cloud. In January 2019, ABC Corporation received a grand jury subpoena issued to it pursuant to 18 U.S.C. 2703, ordering it to produce the data of one of its subscribers concerning an employee of the subscriber. The subpoena was accompanied by a non-disclosure agreement prohibiting for 1 year the ABC Corporation from notifying any person, except its own lawyers, of the existence of the subpoena. The subscriber subsequently filed for bankruptcy, and a trustee has been appointed. So the subscriber to this cloud service, whoever they are, themselves went out of business, presumably partially related to whatever the FBI was investigating. One could only imagine. So the company that was using these services went bankrupt, and so a trustee is being appointed as part of the bankruptcy code. Okay, fair enough. No, the subscriber isn't Cox. I'm assuming the subscriber is a business themselves that is using the cloud for business data storage. So it could be Amazon Web Services. That would make sense, right? Or IBM Web Services or something like that. So it's some sort of business, could be a mom and pop business for all I know, that had some data on the cloud and they went out of business for some reason. So it's some sort of business that's using ABC as its storage mechanism. And the company that was using ABC themselves went out of business, but ABC is still in business. So that's where we are. ABC Corp moved for the district court to modify the non-disclosure agreement to permit it to notify the bankruptcy trustee of the existence of the subpoena and warrant, arguing the non-disclosure obligation are content-based restriction and prior restraints that infringe upon its First Amendment rights. The ABC Corporation asserted that it was proposing a less restrictive alternative to content-based restrictions. ABC Corp argued that the trustee is a disinterested party who has stepped into the shoes of the debtor and has been vetted and approved under the Department of Justice guidelines. Further, the ABC Corp claimed that the trustee controller, the debtor's assertion of the attorney-client privilege, had authority to respond to the government's demand and had a duty to uncover and assert causes of action against the debtor's officers and directors. Although, as we learned from the Big Lebowski, the Supreme Court has routinely looked negatively on prior restraint, it doesn't necessarily always say it's illegal, so we have to see whether or not the dude is going to abide in this particular prior restraint situation. So, Walter, what does the court have to say for us this time? Non-disclosure orders implicate First Amendment rights because they restrict a service provider's speech. Courts apply varying levels of scrutiny to incursions on speech depending on whether the restriction is content-based or content-neutral. Content-based laws are presumably unconstitutional and subject to strict scrutiny. The non-disclosure order in this case are content-based because they prohibit the ABC Corp from conveying information about a grand jury investigation, thus drawing distinctions based on the message. The government has a burden to establish the non-disclosure order survives strict scrutiny. Strict scrutiny requires the government to demonstrate that the restrictions on speech serves a compelling governmental interest, is narrowly tailored to achieve that interest, and is the least restrictive means of advancing the interest. So, prior restraint is deeply frowned upon and is subject to strict scrutiny, as is alluded here. So you have to show, as the court says here, that it's a compelling interest and is narrowly tailored to the interest. So it has to be least restrictive means of achieving the interest. So it's very, very hard to pass strict scrutiny for very obvious reasons. So let's read on. In reference to the application of strict scrutiny here, the government argues that it has a compelling interest in preserving the secrecy of grand jury proceedings. But strict scrutiny sets a high bar for the government to meet. Government officials may not constitutionally punish publication of information absent a need to further the government interest of the higher order. We are convinced, however, that protecting the secrecy of an investigation is a paramount interest of the government. The government interest is particularly acute when, as is here, the investigation is ongoing. The ABC Corp contends the government asserts a compelling interest in preventing notice to the target of the investigation. But ABC Corp misperceives the breadth of the compelling interest that underlies the restriction on speech. The government interest in a grand jury secrecy is not limited to avoiding notification to the target. The Supreme Court has identified several reasons to maintain grand jury secrecy: to prevent the escape of those whose indictment may be contemplated, to ensure the utmost freedom to the grand jury in its deliberations and prevent persons subject to the indictment or their friends from importuning the grand jurors. That would mean bribing, by the way, or threatening. To prevent subordination of perjury or tampering with witnesses who may testify to the grand jury and later appear at the trial of those indicted by it. To encourage free and untrammeled disclosures by persons who have information with respect to the commission of crimes, to protect innocent accused who is exonerated from disclosure of the fact that he has been under investigation and from the expense of standing trial where there's no probability of guilt. I feel like now is a good time to remind people that grand juries are not similar to the ones that you see on Law and Order. The juries that you see on Law and Order are called formally petite juries, but everyone just calls them a jury. And although grand juries have a very similar sounding name, they have a very different function. They have an investigative function. Those functions have been in large part transferred to police and other entities, but they do remain as a function. And they, as part of investigations, can call witnesses and review evidence and other things. And all a grand jury can do at the end of the day is issue indictments, they can issue warrants, but they can't criminally convict someone. They don't have that kind of power. And so a grand jury's function is secret because the grand jury is doing what police basically do. They're doing an investigative function. And for the same reason, police keep their investigations secret while they're investigating. Grand juries also keeping it secret while grand juries are investigating or otherwise contemplating indictments. So, although it shares a similar name to the jury that you are familiar with from Law and Order, it is a closed process because it is part of the investigation, not part of the trial. So I think grand juries have a somewhat unfortunate name because people hear grand jury and think petite jury, and they think, why is this secret? But the two have nothing to do with each other despite the similar names. So that is part of the confusion here and why the law is different as it applies to the two types of juries. The ABC Corp contends the government can accomplish its compelling interest through least restrictive means. If the government could achieve its interest in a manner that does not restrict speech, or restrict speech less, the government must do so. ABC Corp proposes two alternatives: permission for it to notify the bankruptcy trustee of the subpoena, or permission to notify the trustee of the subpoena without identifying the target email account, which according to ABC Corp would prompt the trustee to seek more information from the district court and enter into a protective order to restrict further dissemination. We agree with the government that these alternatives are untenable. They are impractical and would be ineffective in maintaining the grand jury's secrecy. Disclosure by an electronic service provider to a third party undermines the government's interest in maintaining the confidentiality of an ongoing investigation. We cannot and will not assess the trustworthiness of a would-be confidant chosen by the service provider. Simply put, we decline to wade into this swamp of unworkable line drawing. In sum, the non-disclosure gag effect remains at least restrictive means to the secrecy, and for the foregoing reasons we affirm. So that is the end of the matter in the matter of in re application of the subpoena for the ABC Corporation. In this case, we learned the ABC Corporation, that's not their real name, is a cloud service provider along the lines of what Amazon Web Services does or other companies that provide web storage and web applications. And we learned that a client of theirs who was using their storage mechanisms, probably another business, had information stored on there that the government wants as part of a criminal investigation, and that the ABC Corporation was forced to turn it over and not tell anyone about it. The ABC Corporation would like to tell the bankruptcy trustee about it, but the court says no, they have to keep it secret because it's part of an ongoing criminal investigation. So the bankruptcy trustee will have to proceed without this information they don't even know exists, and that is the end of this case. Thank you for joining me as we both read this case together and now better understand the law. If you're enjoying this legal education content, please subscribe to this channel. It really helps us grow. And check out one of our other videos, including the one that's currently being displayed on the thumbnail on screen. Thank you so much for your continued support. And until later, my friends, cheers and goodbye.